provision that allows a miscellaneous application to be brought. It's not there. A miscellaneous application is an importation from the civil procedure rules. The Criminal Procedure Code provides for documents called charges and documents for charging somebody. The state is not telling you the animal code revision, where it is provided for under the Criminal Procedure Code. It is provided for in the civil orders for review, and the reason for review is upon discovery of new material. The state is telling you that you are functus official on an ex parte application, that the court is functus official. I did put to this court that the state does not give birth to children, but it will eat people's children. It sneaks like a witch at night, gets orders and tells you your hands are tied. Cut your hand. They know very well the duration the matter will take in the High Court. And they are eating the children of Ezekiel as we are here. They have no feelings. They have returned to what we call sharp practice, file appeal. It will take time to be argued. A ruling will be done. Then the substantive application will be heard. That is the normal practice in the civil courts. It has been brought before you to delay this matter further. From when we started appearing before you, the state has been moving goalposts, because it is happy eating the children of Ezekiel. When my good friend Martina Swiga will be dealing with the authorities of the right to review, the state will be shocked that this court has jurisdiction to review its orders as many times. We always battle with the state over review of bail terms and bond terms. And it is settled by Justice Kimaro that we can review 20, 30, a million times. But for this matter, we are being told, don't try. Your Honor, it is our considered view that this court has jurisdiction to hear this matter. You have not been shown any section of the law or any authority that tells you that you are functus official. Do criminal courts have functus official? Is it a principle applicable in the criminal law? These students of mine here and others will advise the state that that is an animal in other courts. There is no judgment before this court. The only time the court becomes functus official is when it has given a judgment. Article 49 and Article 50, which my good friend Mr. Kilifi will deal with, talks about the rights of an accused person. In this matter, Ezekiel stands a word of this court. Pastor Ezekiel is a word of this court by virtue that it is his accounts that are frozen. In criminal practice, the darling of the court, the girlfriend of the court, the boyfriend of the court is an accused person, not the state. You know, 55 million Kenyans are against Ezekiel. Even me, because I am part of the state. 55 million Kenyans. That is the state against one individual called Ezekiel. The only protector is you. The state is talking about the public interest. Because they don't give birth to children. They do not care about the other interests that are being trampled upon. You know, I did put it very clearly that this is an attack, a calculated attack against the Christian faith. Instead of the state prosecuting, the state is out to persecute.
They have not availed those documents as ordered by this honorable court. And we feel they were the right parties to address the court on whether they will comply with those orders or not. And thus be praying that we be supplied with the ruling of the court, allowing the suspect in this matter under investigation to cross-examine an investigating officer on the investigations he is conducting on the suspect. And we'll also be praying for proceedings on the same. Pursuant which has been filed dated 15th May 2023, which seeks to rely on Article 159 and Article 47 of the Constitution of Kenya. We have since filed appeal dated 17th May 2023, in which the state indicates that, Your Honor, with tremendous respect, you do not have jurisdiction to vary your own orders as the court became functus official after issuing those orders and cannot vary those orders before the lapse of 30 days. The interested parties should have approached this court, the High Court, for revision or appeal of those orders if they were dissatisfied with those orders. Your Honor, there is no provision under the Criminal Procedure Code which allows the court to review its own orders. In fact, if a court makes a mistake on record, the file is taken to the High Court for revision. As the law only allows for revisions and appeals. Your Honor, we are guided by two authorities. The famous case of owners of Lilian Motor Vessel, which was held that
the parties have of the PO dated the 17th day of honor. A legal misadventure made for the purpose of distracting this honorable court from determining a serious issue that has been brought via our application dated the 15th day of May 2023. Your Honor, in order for the court to appreciate our considered view, we will invite the court to take a cursory glance at the application dated the 15th day of May 2023. And Your Honor, the court is called upon to ask itself, what does the interested party intend to achieve through the application dated the 15th day of May? With humility, Your Honor, the application is an invitation for the court to exercise its power, discretional power, to review orders that were issued by this court on the 8th day of May 2023 on a number of grounds, Your Honor. And most importantly, on the ground that there exists sufficient reason to review those orders. Additionally, Your Honor, yesterday, through the court's proceeding, it was revealed that there was an error apparent on the face of the record that the court intended initially for these orders to be enjoyed for a period not exceeding 10 days. But as we are human, there was a mistake that was admitted, that the intention of the court are not reflected in the extracted order of the 8th day of May 2023, Your Honor. So that is the invitation we ask with humility the court to consider. So, Your Honor, so that you are not distracted, Your Honor, when you read at the preliminary objection, our colleagues propose that the only thing that we could do is to appeal or seek a revision before the High Court. Your Honor, it is common ground that an aggrieved party has a number of avenues that they can explore to find redress. It cannot be in the place of the state to tell us which tool of the many tools that are available to us, an appeal, a revision, or a review that we can use. And Your Honor, the practice of law, in the few years I have been practicing, I liken it to the sport of boxing. which Your Honor have had the advantage of practicing, is that Your Honor, you cannot tell your opponent where to hit. They cannot tell us when we have seen that there is a mistake that the court has done, and the court has the inherent powers to do right, to balance the scales of justice. They cannot tell us not to approach you and instead approach the superior courts. Your Honor, in our practice, when we practice daily here, and dates are issued by this court, for instance, if the court is to make or it is to issue a date that we should attend a court session on the first day of May, which happens to be a public holiday, and the court has written it down, is it not proper and just in the circumstance that a party who has identified that mistake to have been done to inform the court in advance of that error, and for the court to correct that error? A laughable proposition is being made by my colleagues that in view of that error, we should now be approaching the High Court to correct a date that has been mistakenly been issued by this honorable court. Your Honor, I submit with humility that that is not a proper way of looking at the law, and most importantly, those should not be correct or submission that should be entertained by this court, at the very least so that we can safeguard the public from being misdirected, and the many students who are attending to these court sessions, so that they can appreciate the beauty of the law.